So I'll start by introducing the speakers and then sort of providing you with sort of the outline how this is going to go, and providing a brief sort of summary of where we're at. Obviously, we have a recent decision from the Alberta Court of Appeal, so we'll go into that briefly. I'll start by presenting those who will be arguing that the Act, at least parts 1 and 2, are unconstitutional. First, we have Professor Dwight Newman, who's a professor of law and Canada Research Chair in Indigenous Rights and Constitutional and International Law at the University of Saskatchewan, where he started in a faculty position in 2005 and has also served a 3-year term as Associate Dean. Prior to entering that faculty role, he completed his graduate studies at Oxford University, where he studied as a Rhodes Scholar. Joining him on this side of the debate is Aaron Wudrick, who has served as the Federal Director and in-house counsel of the Canadian Taxpayers Federation since 2014. Aaron practiced as a litigator and then in corporate law with an international law firm in London, Hong Kong, and Abu Dhabi, which is interesting, prior to returning to Canada to work as a political consultant and lobbyist. And obviously the Canadian Taxpayers Federation is intervening at the Supreme Court on this case, in this case. Those arguing that the carbon tax, the so-called carbon tax, the Greenhouse Gas Pollution Pricing Act, is constitutional are first Elizabeth May, who is the Green Party of Canada's first elected member of Parliament, representing Saanich Gulf Islands. In 2005, Elizabeth May was made an Officer of the Order of Canada in recognition of her decades of leadership in the Canadian environmental movement. More recently, after the 2019 election, she stepped down as leader of the Green Party of Canada after serving for 13 good years maybe, and continues as parliamentary leader right now for Canada's first federal Green Party caucus. Joining her on this side of the debate is Theresa McClenaghan, who is the Executive Director of the Canadian Environmental Law Association. Theresa holds an LLB from Western and an LLM in Constitutional Law from Osgoode, as well as a diploma in environmental health science from McMaster. Theresa is co-counsel for a group of interveners in litigation that is now before the Supreme Court on this very issue. So just join me in welcoming our panelists for this debate. So the way that this debate is going to work is that every speaker will have 10 minutes. So we'll start with Professor Newman arguing that the Act is unconstitutional, and then we'll go to Theresa arguing that it is, then Aaron, then Ms. May. And then each speaker will get a 3-minute rebuttal, and then we'll go to your questions. So if you do have questions as we're going through this, note them down, and we'll be able to sort of get to those at the end. So I'll start by briefly sort of outlining where we are right now in this litigation. I suspect most of you already know, but for those of you who don't, I will provide that sort of brief summary. So there are 2 parts of the Act that are sort of at issue in this debate. Part 1 of the Act establishes a fuel charge on 22 GHG producing fuels. So this one is sort of characterized as a demand side charge because it's mostly sort of targeting consumers. And then Part 2 establishes output-based performance standards for sort of large emitters, large GHG emitters, and is a little bit more regulatory in nature. That's sort of one of the questions at issue, so I won't sort of get into the debate. But those are the sort of the 2 parts of the Act that are at issue. We have 3 appellate courts, obviously, that have sort of pronounced on this, started with the Saskatchewan Court of Appeal, in a decision that was 3-2, so a split decision, with the majority upholding the Act on the basis of the national concern branch of the federal parliament's peace, order, and good government power. So many arguments were put forward, and today you will get a sense of sort of the breadth of the arguments. Many of our panelists will be speaking to other heads of power, so namely the trade and commerce power, the criminal law power, the emergency branch of federal parliament's power over peace, order, and good government, national concern, and obviously taxation. But the majority upheld the Act on the basis of the national concern branch and explicitly sort of ruled out other heads of power, which the Ontario Court of Appeal didn't feel it needed to do. The dissent in that case said that it couldn't be upheld under the national concern branch, and it also expressed an opinion on the issue of the tax. So whether or not this was a tax or a regulatory charge, and the reason that that becomes relevant, I think, and I think Aaron will probably go into this, is that if it is a tax, then there are constitutional requirements, right? The principle of no taxation without representation is sort of engaged. And so if it's a regulatory charge, that principle is not engaged. And so the dissent sort of went on that and said that one part of the Act, Part 1, was a tax. And therefore had to comply with these requirements. The Ontario Court of Appeal split in 3 separate reasons. The majority finding a narrower head of power than the majority in the Saskatchewan reference. So these judges also uphold the Act under the National Concern Branch. But here the language is sort of a little bit different and a little bit broader. And also I'll get to the language from the Saskatchewan majority, which is that the head of power, essentially, the subject matter, is the establishment of minimum national standards of price stringency for GHG emissions. So a little bit narrower, and you'll understand why when I lay out what the Ontario Court of Appeal said, which was that the subject matter was establishing minimum national standards to reduce GHG emissions. So there's no pricing stringency there. Associate Chief Justice Hoy concurred with the majority in the Ontario Court of Appeal, but essentially adopted a subject matter that was largely consistent with the Saskatchewan majority. The language is a bit different, but I won't get into that. If the debaters want to, they can, but similar in many respects. Then there's another dissent in the Ontario Court of Appeal by Justice Huscroft, who also was of the view that it could not be upheld under the National Concern Branch. Then we get to the Alberta Court of Appeal, which I'm sure you are all aware of, that sort of concludes the opposite and says that this Act, both Parts 1 and 2, are unconstitutional, cannot be upheld under the National Concern Branch. At least the majority says that. The concurring opinion rejects the National Concern Branch, questions its existence and whether or not it should be applied, and refuses to apply it, essentially. And the dissent, Justice Feehan, adopts reasoning, and he explicitly says this, that he is adopting a subject matter, a head of power, that is narrower in scope than the majority at the Ontario Court of Appeal, and he adopts largely the reasoning of the Saskatchewan majority and the concurring reasons of Associate Chief Justice Hoy, though his characterization of the matter is a little bit longer, and so I'll read that. He says that the essential subject matter of the Act is to effect behavioral change throughout Canada, leading to increased energy efficiencies by the use of minimal national standards necessary and integral to the stringent pricing of greenhouse gas emissions. So we have the sort of the pricing element, and pricing stringency comes up again, but it's just a different, slightly different formulation than the other courts. So all around, we have 8 judges upholding the Act under the National Concern Branch of POG, and we have 7 judges saying that it's unconstitutional. And so that's where we are right now going into the Supreme Court and into this debate. So on that, I will get Professor Newman to start us off with 10 minutes.
Good afternoon. The proposition I've been tasked with helping to advance this afternoon is the proposition that the carbon tax is unconstitutional. In order to clarify what it is that we're discussing, I want to set out some definitions, and to set out that in referring to the carbon tax, or what's popularly being called the carbon tax and or the so-called carbon tax, that we're referring to the particular part of the Greenhouse Gas Pollution Pricing Act that imposes the charge on carbon. Now, there are other parts to the Act. They require a different discussion, but the part that prices carbon is the part that's popularly being called the carbon tax. And in talking about the constitutionality of that part, we're talking about an actual statute, not a statute that Parliament could have passed but didn't, but rather the statute that it did pass in 2018, and the part of it in particular bearing on carbon pricing. We're also talking about a question of law, not a question of policy. When the question is whether that's unconstitutional, that's a legal question. It's not a question about what's a good policy on greenhouse gas emissions. And I think that that's very important to be clear on from the outset. And a great deal of the argument in the case has tried to blur those two. But it's very important to recognize that we are talking about a legal question, subject to legal tests, subject to legal standards, subject ultimately to the law contained in the Canadian Constitution. I'm going to advance 3 principal arguments in the next few minutes, and then we're going to rumble. So first of all, I'll say, my first argument is if you are keen on greenhouse gas policy, and particularly are keen on carbon pricing, the federal government could do that in some other way, but instead chose a way that muddled things, that has caused its own problems for itself, and has caused a constitutional problem of enormous proportions, both for that act and for federal-provincial relations in many respects. And so I'll say, when people talk about a carbon tax and whether there's constitutional grounds for that for the federal government, it sounds very simple if you say, well, the federal government has jurisdiction over any mode or system of taxation. The problem is that the federal government wasn't willing to design something that looked like a tax in full terms and that it would admit was a tax in full terms. Instead, it designed this carbon pricing scheme that depends on the backstop scheme, where if they don't like the policy in particular provinces, then they'll swoop in with the federal policy on an administrative discretion exercised by the Governing Council. And that's a very different scheme than just passing a tax across the board, which they would have had the jurisdiction to do. And why this is important to identify at the outset is that siding with the view that the carbon tax, the one that actually exists, is unconstitutional doesn't commit you to the view that the federal government can't ever do anything on greenhouse gas policy, and it doesn't commit you to the view, as actually the POG argument does, that the provinces can't do anything on greenhouse gas policy either. So I want to set that out at the outset, because we may hear appealing arguments from the other side that there's a very serious issue at stake in terms of climate change and in terms of environmental policy, and I'm not going to disagree with that. There are serious matters at stake, but they're not the ones confronted by this legal question. The second argument I want to advance is simply that the federal government's explanations of its own law have to generate enormous suspicions right from the outset in terms of its constitutionality. Because if the federal government has a basis for saying that this law can be sustained under the National Concern Branch of the Peace, Order and Good Government power, which has been its principal argument, then it should have one clear explanation of how that's the case. Instead, it's had a vast array of shifting arguments that it's offered in the various courts and at various stages, and there's something very peculiar about that in many respects. So prior to going to the Saskatchewan Court of Appeal, in their written argument, the federal government argued that they were claiming jurisdiction over greenhouse gases generally as the matter over which there would be federal jurisdiction. Once they arrived at the Saskatchewan Court of Appeal and started making their oral argument, they said, oops, we didn't really mean that. When we wrote greenhouse gases, we only meant the cumulative aspects of greenhouse gases. And then they struggled to explain what that meant. The Saskatchewan Court of Appeal actually rejected the federal argument, but only saved the legislation through adopting the argument of the Attorney General of British Columbia and offering an explanation for the act different than that offered by the federal government itself. So that's very peculiar. So then the Saskatchewan Court of Appeal, having shifted towards a minimum national standards type of explanation, and that's the type of explanation that runs through the various courts of appeal, although different judges put it all a little bit differently. So there's actually a host of minimum national standards arguments at stake. Well, then the federal government has now adopted that type of view in its argument at the Supreme Court of Canada. So they said, whoops, these other explanations didn't work, and now we have a new one again. And by the way, at the Supreme Court of Canada, they said, starting at paragraph 69 of their factum, they said, actually, you should modernize the POG test while you're at it to make sure that our act is okay. So there's something very suspicious about what the federal government has done all the way along. My third argument is really about the implications for the law on POG if the federal argument wins under one of these versions, the most plausible being some kind of version on minimum national standards. And this is where things really hit the road in some ways, is because whatever is said about peace, order, and good government in this case is a precedent for other cases. It's a precedent for the exercise of other federal powers, and it's a precedent on what the law on POG is. And there are several reasons why there would be profoundly problematic implications for the law of POG if somehow minimum national standards were to be fit within it. The first of these is that minimum national standards on greenhouse gases might sound appealing from the policy perspective. But if the federal government can set minimum national standards in this area, it's unclear why they can't set minimum national standards in every other area. Because if the idea of minimum national standards is that provinces are constitutionally unable to create minimum national standards, which of course they can't set standards for outside the province, then there's a new power being created for the federal government to set minimum national standards ultimately in every area. And if you care at all about the idea of having a federal and provincial governments, the very structure of the Constitution is inconsistent with the idea that the federal government can set minimum national standards in every area of provincial policy, or provincial powers no longer mean anything. The second issue here is that there are implications for constitutional interpretation more generally. In particular, if one starts buying the view that the federal government is now putting that the POG test needs to be modernized, as they put it, first of all, the various ways in which they're proposing to modernize it leave a very unclear test, partly because they want to shift the language on different parts of the test with no particular explanation of why on some of the changes that they would make. I guess it's just to introduce trendy new language on some things. So instead of talking about a new matter or a matter that's risen to national dimensions, they want to talk about something that's become transformed, whatever that might mean. The difficulty with that is that there are reasons to stick with older language that's been subject to interpretation rather than just to make up new language that has an unpredictable meaning. Well, in talking about modernizing, the government is essentially arguing for abandoning existing tests, and it's arguing for shifting away from the Constitution as written. There are very drastic implications that could frankly arise, and this is my last point. There's a real tension introduced into federal-provincial relations, and I think the clearest sign of that is the fact that the province of Quebec, no enemy of climate change policy, is actually now intervening against the federal government's greenhouse gas policy because the federal government's argument poses so much threat to the provinces, has so many implications against maintaining federalism and an appropriate federal-provincial balance that they had to do so. I would put to you the argument that we really need to see this legislation declared unconstitutional.
Thank you. I will be arguing that the Greenhouse Gas Pollution Pricing Act is a valid exercise of Canadian federal constitutional jurisdiction based on the criminal law power of the Constitution Act. The greenhouse gas pricing law includes mandatory requirements, prohibitions, and penalties, and seeks to induce change in behavior that will lead to greenhouse gas emissions in Canada. When I was about 11 years old, living on a Trans-Canada Pipeline's natural gas compressor station, did you know that, in southwest Saskatchewan, I had a debate with my dad. The global oil shocks of the 1970s had just occurred, and I said that I was very concerned that grown-ups were going to use up all of the oil and gas and leave nothing for us kids when we were adults. He responded that he was confident there would always be lots of oil and gas. Smart geologists would find more, and smart engineers would come up with new technologies for energy supply. Little did I know then that I was on a trajectory to become an environmental lawyer, nor that he would turn out to be more right than his bosses even knew at the time. Or that today we'd be arguing about needing to leave much of that extra oil and gas in the ground, rather than allowing the greenhouse gas emissions from its combustion to add to the levels of carbon in our atmosphere. I didn't know then the words intergenerational equity, and I certainly didn't know then that the intergenerational equity issue of our time would center around a climate emergency. My childhood demonstrated that we are connected to global events and that our Canadian energy economy is completely interconnected across the country. Alberta natural gas reached markets across Canada by coursing through pipes located meters from the houses I grew up in, through Saskatchewan, Manitoba, and Northern Ontario on its way to Toronto and Montreal. The decisions to finance exploration and development of the gas resources, as well as the infrastructure to get it all to markets, were then primarily made on Bay Street, in Toronto, and internationally, worlds away from the prairie and northern bush environments I saw right outside of my homes. A lot has changed since then. Since then, we've negotiated binational and international treaties on many critical issues affecting our planet's health, like acid rain, toxic pollution in fisheries, and climate change. We have also found out that environmental issues, including climate change, affect the most vulnerable among us, whose homes and livelihoods are the most jeopardized with crop failures, melting permafrost, rising sea levels, horrific storms, spread of invasive species, pathogens, and insects, changes to natural cycles, and unheard of heat events. We have collective interests in protecting our natural environment for our own well-being and for the rest of the planet's ecosystem. Since Keeling began to measure CO2 concentrations from a monitoring station in Hawaii and his celebrated paper in 1961, and I first heard of the possibility of climate change at university in 1981, the science now overwhelmingly assures us that dealing effectively with the climate emergency is imperative. All Canadian governments, federal, provincial, municipal, and Indigenous, must have the jurisdiction to act to protect their residents and the entire ecosystem on which all of us depend. As you know, environment is not assigned as a specific head of power listed under Section 91 or 92 of the Constitution Act 1867. Like health and other common concerns, environment crosses many constitutional topics, and the authority to act can be found under multiple plenary, specific, and residual heads of power. As Mr. Justice Laforêt in the Hydro-Quebec decision said in 1997, the protection of the environment is a major challenge of our time. It is an international problem, one that requires action by governments at all levels. CELA, my organization, intervened in that case, and many others, such as Spraytech and Castonguay, where we argued to support municipal, provincial, and federal jurisdiction to act in order to protect the environment. In Hydro-Quebec, the Canadian Environmental Protection Act, CEPA, which controls toxic substances and pollution, was upheld in reasons by Mr. Justice Laforêt, stating that the criminal law power was the justification for federal jurisdiction. He stated, "I entertain no doubt the protection of a clean environment is a public purpose within RAND's formulation in the margarine reference, sufficient to support a criminal prohibition. It is surely an interest threatened which Parliament can legitimately safeguard, or to put it another way, pollution is an evil that Parliament can legitimately seek to suppress. Indeed, as I indicated at the outside of these reasons, it is a public purpose of superordinate importance. It constitutes one of the major challenges of our time. It would be surprising indeed," he said, "if Parliament could not exercise its plenary power over criminal law to protect this interest and suppress the evils associated with it by appropriate penal prohibitions. In the more recent Syncrude case in 2016, the Federal Court of Appeal likewise agreed that the criminal law power provided the underpinning for valid exercise of federal jurisdiction, also under CEPA, which imposed new requirements for a minimum 2% renewable fuels content. This requirement was part of a broader federal strategy to reduce greenhouse gases. It was confirmed by the court to be a valid use of the criminal law power. Furthermore, the utilization of market forces as part of that strategy did not take away from the valid exercise of the criminal law power in that case. Likewise, the greenhouse gas pricing law is part of the same valid criminal law purpose, reducing emissions of GHGs in Canada. It contains prohibitions on emitting greenhouse gases by industrial emitters unless they register and pay charges as specified, prohibitions on importing or selling specified fuels without paying the specified charges, and penalties to ensure compliance. The evil addressed by the greenhouse gas pricing law is the unbridled release of greenhouse gases in Canada and their contribution to the accumulation in the atmosphere of dangerous, planet-altering levels. There is no question this is a valid criminal law purpose, as is control of pollution generally. The global community has been attempting to deal with greenhouse gas emissions since the UN Framework on Climate Change in 1992 following the Rio Declaration, and over subsequent decades through Kyoto and Paris. In the litigation dealing with the greenhouse gas pricing law, all of the provinces arguing against the validity of the Act concede that action is urgent. The time has long passed when voluntary measures or patchworks of non-integrated efforts can adequately address the problem. We no longer have time for that. The International Panel on Climate Change told us in its summary for policymakers in 2014 that urgent, immediate, widespread action is required. That IPCC report said pathways limiting global warming to 1.5% with no or limited overshoot require rapid and far-reaching transitions in energy, land, urban, and infrastructure. The systems transitions that are needed are unprecedented in terms of scale, but not necessarily in terms of speed, and imply deep emissions reductions in all sectors, a wide portfolio of mitigation options, and a significant upscaling of investments. Accordingly, binding national action to address greenhouse gas emissions is a legitimate exercise by the Canadian federal government under the criminal law power, just as it was to address emissions of toxic substances in Hydro-Quebec and just as in Syncrude. The fact that prohibition includes charges on emissions does not negate the legitimacy of this use of the criminal law power. It is open to a government acting within its authority to utilize a range of measures to accomplish the necessary goals. Utilizing market forces such as carbon pricing as a backstop to the efforts of the provinces is appropriate as part of a scheme of control based on the criminal law power, as part of the government's overall strategy to reduce greenhouse gas emissions, just as it was in Syncrude. In 1970, when I was practicing my debating skills with my father, CELA was being established right here at the U of T Law School by law students like those enrolled here in the faculty. My younger self would be fairly astonished that I would be here today working at CELA and speaking to you. I also might have been quite frightened if I knew the trajectory we would take as a global community and at the role that fossil fuels have played in that path. For the sake of all of the current 8-year-olds around the world and all of those to follow, and the rest of the planet's inhabitants, it is critical that we support our governments to act at all levels with meaningful, effective, binding legislation, using all of the tools in our legal toolboxes to reduce greenhouse gas emissions. There's no doubt we collectively have the knowledge, the technology, the resources, and the ability to course correct. Law is essential to make sure we do it, and the greenhouse gas pricing law is a legitimate federal exercise of criminal law power to that end.
Good afternoon, everyone. I am a long-time attendee of this conference each year. I'm very excited to be speaking at it for the first time. I'm very pleased, of course, to be here on behalf of my organization, the Canadian Taxpayers Federation, who has been an intervener in all three of the appeal court references and will be appearing as well before the Supreme Court. And I'm very honored, especially to share the stage with three such eminent legal minds. I hate to disappoint the moderator, Jesse. I am not going to talk about taxes today. I so rarely get the opportunity to talk about anything other than taxes. And so I'm going to take that opportunity. I want to use my time today to make 3 points. And so I will just lay those out and expand upon each in turn. Dwight has generously touched upon several of them. And given that he was cited so many times in the Alberta Court of Appeals majority, I feel I'm on the right track if I'm duplicating what he is saying. So the 3 points. First, I just want to stress the constitutionality of this act. It cannot be determined through an analysis of the effectiveness or the popularity of the policy and must be made solely through an analysis of our existing constitutional architecture. The second point is that for the act to be constitutional, and I choose this particular ground, I know Theresa has advanced a different argument about criminal grounds, but the ground which the Ontario and Saskatchewan courts found that the act met the national concern was the national concern doctrine under the POG power. So I want to discuss that and talk about the two-step test that's laid out in Crown-Zellerbach, what we might call the indivisibility branch and the reconcilability branch of that test. And I would submit that, in fact, that parts 1 and 2 of the Act do not meet either branch of that test. And the last point I want to make is to argue that if, in fact, this Act is found to be constitutional, it would represent a potentially massive expansion of federal power at the expense of the provinces and effectively modify Canada's constitutional architecture. Now, the first point might seem a little bit trite, but I think it does bear repeating. And that is that it is not the court's job to duplicate the subjective policy-making role of the legislative branch. Whether a law is popular or unpopular, or frankly good or bad, may be of paramount concern to legislators, who of course need to get themselves elected, but it should not concern the courts whatsoever. The courts are the only institution standing between a legislative abuse of power and the public, and they must take great care not to stray from this essential rule or allow it to be diluted by any other pursuits. Turning to the national concern doctrine, I think the first thing I would note is that it was by design supposed to be construed narrowly. As the majority in the Saskatchewan Court of Appeal observed, quote, invoking the national concern branch of POG is necessarily a delicate business. It carries with it the real potential of significantly altering the way powers are allocated between Parliament and provincial legislatures, and hence of altering the balance of federalism itself. In short, it is a big deal. And the threshold must be high precisely because we are talking about something as serious as modifying the Constitution. Now, in Crown-Zellerbach, Justice Ledane laid out what has become and what all the appeal courts treated as the accepted test about whether a law meets this national concern. And it's twofold. First, for a matter to qualify as a matter of national concern, it must have a, quote, singleness, distinctiveness, and indivisibility that clearly distinguishes it from matters of provincial concern. And secondly, it must have, quote, a scale of impact that's reconcilable with the fundamental distribution of legislative power under the Constitution. Now, on the first branch of that test, it's very difficult to see how the regulation of greenhouse gas emissions is distinct and indivisible from matters of provincial concern. I would argue, in fact, it's quite the contrary. The impact of the Federal Act targets many areas exclusively within provincial jurisdiction, including the development of natural resources under Sections 92A and mines under Section 109. Nor is it enough for the federal government to simply declare a, quote, national standard necessary and then rely on this characterization as determinative. As Justice Huscroft noted in his dissent in the Ontario Court of Appeal, quote, there are many things that individual provinces cannot establish, but it does not follow that those things are matters of national concern on that account. If it were otherwise, any matter could be transformed into a matter of national concern simply by adding the word national to it. This point was also touched on by the majority in the Alberta Court of Appeal when it drew a distinction between the marine pollution that was at issue in Crown-Zellerbach and the regulation of greenhouse gas emissions, noting that the key reason that marine pollution was found to be legitimate under the national concern doctrine was not that water crosses provincial boundaries. It was that it was not possible to observe and determine the source of the pollution. Now, if you contrast that with greenhouse gas emissions, that is not an issue because we are able to determine from which province GHGs are emitting. I would submit that the distinction drawn between Crown-Zellerbach and the case before us is the proper conception of the national concern doctrine. It is a very limited doctrine that should only apply to fill gaps where provincial coordination and aggregation is not possible to essentially create a national standard, rather than as a mechanism to convert what are properly provincial powers into federal powers. With respect to the Act being reconcilable with provincial powers, there's been much weight placed both by the Saskatchewan Court of Appeal, and particularly the Ontario Court of Appeal, on the fact that the Act presently operates as a minimum floor and therefore does not entirely exhaust provincial jurisdiction. In writing for the majority in Ontario, Chief Justice Strathy rejects the contention that it's irreconcilable solely because he says this is a minimum standard. It does not exhaust the power of the provinces to act. But with great respect to the Chief Justice, if the validity of the Act turns on this condition, what remains to stop the federal government from simply raising it later on? It's very difficult constitutionally to open the door a crack and not invite the level of government with that power to open the door further later on. As the majority of the Alberta Court of Appeal, which was very attuned to this problem, wrote, quote, "The final shape, substance, and outer limits have not yet been revealed of this legislation," which is probably why they also describe the Act as, quote, "a constitutional Trojan horse." Which brings me to my final point. The totality of the case law surrounding the national concern doctrine, including both the anti-inflation reference and Crown-Zellerbach, are chock full of warnings about accepting too broad an interpretation of the national concern doctrine, precisely because of the impacts on the division of powers. Simply put, to find this Act constitution is to set a troubling precedent that has absolutely nothing to do with climate change or even carbon taxes. Rather, it risks creating an easily exploitable backdoor for the federal government to expand its powers at the expense of the provinces. This Act is not a surgical tool carefully tailored to backstop aggregate action taken by the provinces. It is a broad and very blunt instrument that contains within it the power to usurp broad areas of exclusively provincial jurisdiction. And for that reason, this Act must be found unconstitutional. Thank you.
Good afternoon. I want to begin by acknowledging that we're on the traditional territory of the Huron-Wendat, the Seneca, and most recently, the Mississauga of Credit River. I also want to acknowledge, is he still here? Scott, you here? A friend of mine from Parliament is here, Scott Reid, the Honourable Member for Lanark, Frontenac, and Kingston. So yearning as I do to run for Speaker someday, I don't want to leave him out. And I also have to acknowledge that, because it's not in my bio, and I'm torn about this because I'm terribly intimidated to be in this place and in this room with so many learned academics and practicing lawyers, that I am a graduate of Dalhousie Law School, graduated in 1983, and was admitted to the bar in Nova Scotia and the Law Society of Upper Canada. I don't know if that helps or hurts me in this instance, but my intention, having not practiced law in a very long time, is to assure you that I approach this issue as a lawyer, not as someone looking at the politics. So I was surprised to hear my honourable colleague, Professor Newman, advance an argument that I think was far more political than legal. I would put to him and to all of you that just because Liberals are incoherent does not mean that they're unconstitutional. And I would actually extend that to say that Liberal and Conservative governments can put forward all kinds of things and be slightly incoherent, but not unconstitutional. I also want to make this really clear that all of these judgments deal with important issues, and they deal with them soberly. These three courts, Alberta, Saskatchewan, and Ontario, are dealing with complicated issues that really matter, because the Constitution of Canada really matters, and one mustn't play fast and loose with it for political exigencies. And I would put it this way. One of the key concepts that underlies all of this is, what does federalism look like in Canada? Yes, we can argue the niceties of Section 91 and 92. We can go back over Crown-Zellerbach and the anti-inflation case. But what what people are grappling with is what makes this country work. And I'd put it to all of you, and you've heard an argument already, that the federal government could have done this another way. Sure, it could have. But the motivations for a backstop, stringent minimum carbon price have to do entirely with political sensitivities to protect a functioning federalism. And that's because before the federal government came to the point of wanting a nationally stringent bottom line carbon price, the provinces of British Columbia, Ontario, and Quebec, and to a lesser extent other provinces, had some form of their own pricing scheme in place. It would have been, in terms of the damage to federalism, impossible to imagine that my home province of British Columbia would abandon a carbon price and a system that had been in place since former Premier put it in place so long ago now, that it doesn't make sense to imagine that the government would do other than develop a backstop. That means, by its very definition, this is crafted as law, to say that the Greenhouse Gas Pollution Pricing Act is crafted to be highly specific and fit into a template within which provinces that have their own schemes are untouched by it. This is an unusual piece of legislation. In other words, it's not an expansion of federal jurisdiction over all aspects of any area of policy. It's a quite limited effort to ensure that where a province doesn't have in place a stringent minimum carbon price, the federal government provides one. And it can't possibly be considered a tax, because any definition of tax I've ever seen, and I've in the last few days been looking up all of them, suggests the purpose of the tax is for a government's spending or general revenue purposes. And since the money collected under the Greenhouse Gas Pollution Pricing Act is returned by one means or another to the source, therefore it is not vulnerable to the attack that it's a tax and not legitimate. There's important reasons that we make sure that legislation in this country is constitutional, and we make sure that we examine any assertion of federal powers being expanded under matters of national concern under peace, order, and good government. We do that because it is a very large change to our Constitution to allow a federal government, any government, to say, we've decided this is national concern and it meets these tests, and therefore. The reason the tests in Crown-Zellerbach are so specific and rather onerous, the tests of singleness, distinctiveness, and indivisibility, first determining the pith and substance of the act and then subjecting it to these tests, the process of characterization and classification, are not simple. They have to be quite constrained. They have to be quite narrow. Otherwise, a federal government could, as some of the straw men put out earlier in this argument, would be able to expand federal powers in ways that were illegitimate. I put to you that the fact that the majority of the courts in Saskatchewan, Ontario, and the dissent in Alberta find that the National Greenhouse Gas Pollution Pricing Act meets all the elements of the Crown-Zellerbach case is a very strong support for the fact that this is narrow in its conception and meets all the tests for national concern. It's instructive as well, and I don't know how forcefully to put this, but I want to argue in the alternatives, something that the federal government didn't argue. Before I do that, I wanted to make reference to one more aspect of the arguments that went forward in the Saskatchewan court in the majority decision of Chief Justice Richards, because this also leads to this question of how do we cope with climate crisis. We are talking about a legal analysis of constitutional law today, and we're also talking about a current crisis and how we respond to it. But I think it's very important to note what Chief Justice Richards said for the majority in the Saskatchewan court, that, quote, greenhouse gases do not respect provincial boundaries. Failure of one province to take action in respect of emissions will have impacts in other provinces. I want to lift that up and make it global. We're in a global crisis. Failures of one country to take action in respect of emissions will have impacts on other countries. We are part, as all of these cases have canvassed, all the courts have done a very good job of describing the fact that none of them doubt that the climate crisis is a real issue, no one doubts that it's important, and that governments need to take action. What I think is missing from all the argumentation and all the decisions of the courts is the other head of power under peace, order, and good government, within which the federal government could have acted and which I think the Supreme Court should take into account. It is certainly put forward in the arguments from a number of the interveners, noticeably the David Suzuki Foundation. That is, we're in an emergency. Emergency powers, such as those supported in the Anti-Inflation Act case back in the 90s, are really very, very clear. We must acknowledge that right now we are in, I said back in the 90s, I'm sorry, 1976 anti-inflation case. We're in a situation within which failure to act in the next few years, not till 2030, the next few years, could condemn our society, all of humanity, to the collapse of human civilization before the end of this century. If that sounds extreme, I'm sorry, but the economists at J.P. Morgan this week had a document leaked that said they'd concluded it was a threat of human extinction, so I'm being moderate in my views. The Intergovernmental Panel on Climate Change report to governments from October 2018 made it very clear that the goal of the Paris Agreement to hold global average temperature increase to no more than 2 degrees Celsius and to strive to hold it to no more than 1.5 degrees, all of this text is found in all the various decisions. But that's been interpreted since we signed the Paris Agreement in 2015. That's been studied and analyzed and held up to scientific scrutiny such that we now know 2 degrees is far too dangerous. We're in a global climate emergency within which we don't have the luxury of time. I think the emergency arguments will work here, would work better here, and for that matter, Parliament passed a motion in June 2019 acknowledging that we are in a climate emergency. Now, just as the national concern tests are not without their hurdles, and they are significant in being narrow and stringent, as I've gone over, the emergency test isn't easy either. But Mr. Justice Laskin in the Anti-Inflation Act case made it very clear, and I'll quote from his ruling, "It may be that the existence of exceptional circumstances is so notorious as to enable the court of its own motion to take judicial notice of them without reliance on extrinsic material to inform it." That screams climate crisis to me. The other downside of the emergency argument will be pointed out that it must be seen as temporary. Again, there's significant commentary on that from learned, the late Peter Hogg, on the fact that temporary application is not necessarily always the case. But the climate emergency requires that the actions are temporary. We either save ourselves or we don't. In this emergency, the actions we take are temporary. The end place when we no longer need them will be the place in which we have landed in a planet that has a new carbon dioxide equilibrium such that we are no longer in danger. Thank you.
Thank you to all our panelists. Now we're going to get into the rebuttal round. So we'll have each speaker, we'll start from the top. We'll get 3 minutes in rebuttal, and then we'll go to your questions. So start thinking about that now. Professor Newman, rebuttal.
When Saskatchewan first launched its challenge to the carbon tax legislation, there were many suggestions that it had no legal argument at all. There were people that called it political foot stomping, and there were people that said it was basically not a real case. What we're starting to see is that there is very much a real legal case, and we've seen good arguments on both sides today. I'm going to try to respond to a number of the arguments put on the other side, and then quickly restate a key argument on the side of the legislation being unconstitutional. Ms. McClenaghan first emphasized the importance of all governments being able to act on environmental issues. And I think that is a theme that's run through various pieces of the jurisprudence. But that's actually an argument against the assertion of the POG power in this case, because as we've emphasized on this side, the use of POG requires something that meets the test of singleness, distinctiveness, and indivisibility. And by definition, that's something that can't be divided amongst the provinces. And when something is placed in POG, it becomes something under the exclusive control of the federal government. So something along the lines of greenhouse gases as an exclusive power of the federal government would actually exclude future provincial action and be very problematic indeed from that perspective. Ms. McClenaghan also argued that the criminal law power could be used instead of the POG power. With respect, I don't think that works for the tax part of the legislation, the so-called carbon tax, the carbon pricing, which isn't structured in the form of prohibitions backed by penalties as needed for the legal test. Ms. May has said that I made the argument that because politicians are incoherent, that there's an unconstitutionality that arises. If I made that argument, there would be a lot more things that were unconstitutional than what we're talking about. What I suggested is that the legal argument needs to be coherent over time. There needs to be a conception of what's in POG, or there isn't something that makes sense to say is in POG at the end of the day. There was the suggestion that the provincial the backstop structure was to protect provincial sensitivities, and that may be the case. There may well be an irony in the fact that the federal government can't structure certain legislation in that way. The securities reference saw the striking down of national securities legislation structured with opt-out provisions because that was essentially an admission that the provinces could act in an area rather than being unable to act in an area. It's actually a reason to say that the legislation is unconstitutional under POG. And on the temporariness element in the argument for the emergency branch, I would just say that there's a consistent line of case law that does emphasize the need for legislation to be temporary to meet that test. This legislation unfortunately doesn't meet the test and does need to be declared unconstitutional, principally because of the wider consequences of what it is that needs to be said to fit it into POG, and the consequences that has for many other areas of federal-provincial relations.
Thank you, Professor Newman. Theresa?
Thank you. First of all, with respect to the point about the structure of the legislation and whether it meets the criminal law power, we can point to several examples where the courts have upheld federal law based on the criminal law power with a wide range of structures, such as the requirement to register firearms or the requirement to use certain packaging in the tobacco cases. And in those examples, the courts have found that those kinds of requirements are part of the regulatory scheme based on the underlying valid criminal law power, as we argue is the case here. In terms of the ability of governments to act, the criminal law power does not raise that problem. It's explicitly permissible for the provincial governments to act, and the only constraint is whether compliance with the one law would become impossible because of compliance with the other. And so, for example, in the spray tech case dealing with cosmetic pesticide use, the Supreme Court explicitly said that all of the governments should be encouraged to act, and that that kind of a test should be applied to determine their validity. In terms of the question of the balance of power and the singleness, distinctiveness, and individuality of the matter as described by the courts, the argument that we've made in advancing the criminal law power and even the trade law power is that it's useful for the court to pay attention to all of the possible heads of power and make a decision based on that array of possibilities. And the trajectory for the Hydro-Quebec case is informative because that case went all the way to the Supreme Court of Canada, with POG being argued by many and upheld by the lower courts there. But then Mr. Justice Laforêt found he didn't need to rule on POG and instead upheld it on the criminal law power. And we argue that that is a very tenable result here.
Thank you, Theresa. Aaron?
Thank you. Just a couple of points in response. I certainly, I do want to commend and I admire the passion of the people arguing that the legislation is constitutional. It's clear that no one is disputing that this is a very serious issue that deserves the full attention of governments at every level. But I think the importance of an issue, we get into a very dangerous place when we start using importance as a basis, as a grounds for trying to contort the Constitution in a way to give powers to the level of government that we want to give it to. The argument that the minimum standard for carbon pricing is legitimate. To touch on what Dwight had said earlier, there is nothing particularly unique about carbon pricing. There are many different ways to fight climate change, to reduce carbon emissions. To say that the federal government should have the power to create a backstop in that area, the obvious question is, why should they then not have the power to create a backstop in any other area where they argue they are trying to reduce emissions? I come back to the analogy of opening the door a crack. If it's open a crack, it can be opened all the way, and you really upset the balance of powers between the federal and provincial governments. The other point I just addressed briefly is on the issue of whether the national emergency doctrine can be used under POG. I know that it has been advanced at the courts. There hasn't seemed to be any uptake thus far. That doesn't mean that the issue of climate change is not an emergency. I would suggest that it's actually an international emergency and not a national emergency, and the national emergency power is conceived of as a way to empower the government with a tool to address an issue which is within the control of Canada on its own. If you take an issue like inflation, we have, the government sets the bank rate in Canada. The government is able to address issues. To take another example, something like poverty. If you were to declare child poverty a national emergency, theoretically, a federal government would be able to address that issue because there are a finite number of children in poverty in Canada, and you would know when you had solved the emergency. The problem with using climate change, framing it as a national emergency, is, both the Prime Minister, Catherine McKenna, I'm sure Ms. May and Theresa would agree, it is an international emergency, and Canada's ability to combat it is contingent upon other parties acting. So there's no way for Canada to address this emergency on its own, and so there is an emergency which, once declared, would essentially, I don't know if it has to be temporary in the sense of a little while, but it would be an emergency that would essentially be open-ended. And then the last point I would just make is I really do not see, if this piece of legislation is found to be unconstitutional, I don't see it as a defeat of a setback in the fight against climate change. It's just a defeat of one particular piece of legislation, and the federal government has many other tools at its disposals that it could use and bring forward new legislation.
Thank you, Aaron. Ms. May?
Sure. I want to start by agreeing with Aaron. There are many other tools the federal government should be using, because we are, and all of these cases refer to, by the way, our goal at 30% reductions below 2005 levels by 2030. The courts are not keeping up, nor are the legal arguments to the courts keeping up with the science. And I mentioned the Intergovernmental Panel on Climate Change report, which was a special report on 1.5 degrees, which makes it very clear that we have no alternative if we want to survive as a species in a hospitable climate, in a livable planet, but to hold to 1.5 degrees. The target Canada currently has will blow right by 2 degrees. So we have an obligation as part of the international solution, to which Aaron refers, that we do our best. We are now not doing our best. We're doing far from it, and we have a requirement under the Paris Agreement this year to improve our target. I mention that because we now have another piece of jurisprudence coming to us by way of the UK, in which for the first time a court has struck down a project, the third runway at Heathrow, because it was found to be inconsistent with the UK government's commitments to the Paris Agreement. I think that suggests exactly how much the national and one specific project intersect with the global and the demands on this issue. To return to the more narrow aspects of rebuttal and to go to Dwight's point about securities law, I do note that the Supreme Court in the securities reference in 2011 said that it demands a respect for constitutional division of powers and maintenance of a constitutional balance between federal and provincial powers. Having backstop legislation so that the provinces that have moved with their own schemes, and they're different, right? You've got cap and trade, you've got fuel-based carbon taxes, you can design carbon pricing any number of ways. And the reason that it's different from other areas of government regulation or interference, or it's certainly not a tax, is that all the economists who are studying this want to make sure that you've got at least a national carbon price. Otherwise, it doesn't work. You get tax leakage, you get carbon leakage, you have an incoherent policy. The economists are telling the politicians, you've got to get this right. And that's why there's a backstop. As I mentioned, Premier Gordon Campbell's BC carbon tax being the first one in place. And again, it wasn't a real tax because British Columbia residents got the money back in tax reductions as we paid our taxes. But the court adopted the argument from the Attorney General of British Columbia that assigning the matter to the federal parliament must not disrupt the fundamental distribution of power that characterizes Canadian federalism. I submit this does not. And in one last point, I want to add an argument that I think is quite legitimate on the emergency aspect or in the national concern aspect of this, and that's to remind us of the double aspect doctrine. It goes all the way back to Hodge versus the Queen in 1883. But we can have areas of key public policy that are dealt with both at the provincial level and the federal level. This is one of those. And a very stringent backstop to carbon pricing is a necessary but insufficient condition and very constitutional.
All right, thank you. Join me in giving a round of applause to our debaters. So I'll ask those who have questions to line up at the mic. I think there's a mic there. I'll start off by asking a couple questions, one question to each side myself as I wait for people to line up. So to those supporting the constitutionality, the question is, surely climate change as a problem is a fairly recent vintage in the sense that our fathers of Confederation, certainly the science surrounding climate change would have been unknown to them in 1867. And Ms. May mentioned the carbon leakage issues and sort of the provincial inability there. So isn't that fact, specifically the carbon leakage, but also the evolution in climate science, isn't it that fact that makes this a matter falling within the national concern branch of POG?
I guess I'd say on that of course, the science on climate change was unknown in 1867. The same phenomenon wasn't there in quite the same way as is accelerating in a more highly industrialized world society. At the same time, we deal with that development of new challenges by permitting different governments to act in accordance with the division of powers. And there have been many new challenges that didn't exist in 1867 that have been addressed through an allocation within the existing division of powers. It doesn't mean that something automatically goes within the POG power. The POG power is a particularly concerning one, and just responding to the last point on the double aspect suggestion, a lot of the case law says that POG matters aren't subject to a double aspect, and that fits with the sense of why things go in there. If they're single, distinctive, and indivisible in the sense that the provinces are constitutionally incapable of dealing with them, it's very difficult to then say, well, it's in the federal hands, but the provinces can also deal with it when you just said that they're incapable of dealing with it in constitutional terms. And so it's important to locate things not within POG, but within the other heads of power.
Just one other quick comment. I think the distinction is between whether or not the provinces have the capacity to introduce something, or it's not that the provinces don't have the power to do something. It's that they are not doing it in the way that the federal government would prefer. If this law is allowed to stand, a province could take any number of other actions that are not carbon pricing that would reduce emissions, and yet they would still be subjected to a minimum backstop. So I would suggest that the national concern doctrine comes into play when it is demonstrated that the provinces on their own do not have the capacity to deal with an issue. It is not about the provinces having to deal with the issue in a particular way as prescribed by the federal government.
All right. And to the other side, specifically on the emergency branch, Professor Ronald Watts, or the late Professor Ronald Watts, who's a professor of comparative federalism and the principal at Queen's, in his sort of magnum opus on comparative federalism, sort of lists two federations in which there are emergency powers that permit sort of the transformation of legislative powers from sort of the subnational level to the national level. And those two federations are Canada and India. And in India, the declaration of emergency is subject to quite a stringent judicial review. It has to be temporary in the sense that there's actually a time limit placed on the emergency before Parliament can then adopt the law again. And then even then, there's a limit on how far it can go. And so it seems that Canada is sort of placed in the category of having a more relaxed emergency branch as compared to sort of India. And so don't you see relaxing that even more in some way incompatible with the fundamental federal structure of our country, especially from a comparative perspective, right? Most federations, absent an amendment, of course, amendments can't just be done via one branch sort of adopting a law and saying that it's an emergency. So this is more about the architecture and the balance of our federation.
I would submit that, well, first of all, the invocation of the emergency branch of peace, order, and good government was not necessary for the majority of the judges who've reviewed this piece of legislation to find that it's constitutional under the national concern branch of peace, order, and good government. Personally, and reviewing the factors that were put before the court, I think it's worthwhile the Supreme Court of Canada turning its attention to the question of emergency. The articles almost uniformly say, yeah, we understand emergency if you're talking about a war. Folks, we're at war. We are facing an existential threat. That's not language you see about inflation. Really? It's an economic, it was a real problem. It was a national issue that was deemed an emergency by the Supreme Court of Canada in the 1970s. We are literally looking at the threat that we will be unable to continue human civilization. We will be unable to ensure that our kids have a livable world. If there was ever a time that peace, order, and good government emergency powers are invoked, I believe it would be now. Now, I'll go quickly to the question of temporariness because I didn't read out all of Peter Hogg's quote, but I really love it. Professor Hogg opined that you really didn't need to make sure it was temporary. Now, as I said in my opening argument, it will inevitably be temporary because actions, whether of national concern or not, taxing greenhouse gases isn't about keeping them in place. It's about ratcheting up the tax over time such that the amount of carbon available to be taxed continues to drop till there's none. That's one of the reasons that sensible economists don't want to make it a source of revenue for general government spending because they were then dependent on it. The goal here is to get rid of it. So either under national concern or emergency, it's inherently limited and temporary. But I do want to read what Professor Hogg said. Quote, one is entitled to question, however, the usefulness of the, I'll put in brackets, temporary limitation. It is in any case primarily formal, because an ostensibly temporary measure can always be continued in force by Parliament, while an ostensibly permanent measure can be repealed at any time. More importantly, an emergency, although itself temporary, may be caused by structural defects in the social or economic order, which need to be corrected not only to cure the emergency, but also to prevent the occurrence of future emergency. Preventative legislation would surely have to be permanent. It's an interesting question whether when we look at the climate emergency, and Parliament did pass a motion that it was not only a national emergency, but a global emergency, and I would submit the number of forest fires, floods, threats to life and limb constitute a national emergency, not somehow a global one that leaves us alone till we step up. This is a case where both national concern under POG and emergency powers under POG can be defended, I think, quite forcefully as constitutional.
Okay. All right, we'll go to questions. Just present yourself and then ask your question.
Good afternoon. My name is Ken Peel. I practice law here in Toronto. Thank the panel for both the quality of their respectful arguments and in particular for the civility of the argument which at times is in contrast to what we hear from the politicians. I would appreciate perhaps each side commenting on elements of the Constitution Act which have not been dealt with today, provincial control over resources, and the extent to which provisions such as Section 109 of the Constitution Act and certain of the other provisions which deal with the property and resources of the respective provinces. Section 109 dealing perhaps more obscurely, but with the important issue of all lands, mines, minerals, and royalties belonging to the various of Canada, Nova Scotia, New Brunswick, and so forth, then continuing on to the respective provinces. The 1905 agreements involving Saskatchewan and Alberta, 1930 agreements between the various provinces and the feds, all aiming to the conferral of authority over the provinces in relation to resources. So arguably, for example, if you have authority over coal or timber, which would have been the main focus back then, does that somehow stop at the ability to burn them or to deal with the containment of ash, smoke, or CO2? So just a question as to whether there are additional provisions in the Constitution, particularly as to provincial control of resources, which might be invoked by either side.
Professor Newman, you want to address that?
Okay. Since we're shifting a bit to the discussion period, I maybe will just say, depending to whom the future questions are addressed, that at the outset, a debate is by its nature a bit confrontational, but as you've observed, we've had a very civil debate, but I think we should extend even from that, and I'd just say I appreciate that we're in the presence of two people who, although on the other side of a legal debate, have really fought for environmental causes that they believe in and that matter to Canadians. And there's no doubt in my mind that we're in the presence of two great Canadians, and it's a great pleasure to welcome them to the Runnymede Society. In terms of... In terms of the particular question, I guess I would just say that in many respects the default constitutionality lies with the provinces because of the various kinds of provisions that you've outlined. The provinces naturally have a lot of jurisdiction dealing with resources, dealing with provincial lands, dealing with various other matters as outlined in the provincial powers. And there will be instances where the federal government certainly has authority over environmental matters and can exercise authority based on some of its heads of power, and it has done so on some matters using the criminal law head of power. It's used the fisheries head of power very effectively at times, given a broader interpretation of that than some judges might have given to it, but one that protects any waters where there are fish, essentially. The issue of POG is really one where there would be a bit of a takeover of provincial authority that otherwise normally is there. And that's part of what really has concerned a number of the provinces that have challenged the legislation. And it is a loss of a default authority that's there. And they would normally allow the provinces to be engaged in climate change policy of their own, as British Columbia was.
So I'll start. In terms of the scheme of the Constitution, there are several heads of power, as was just mentioned, that kick in as soon as matters are not restricted to the boundaries of that province. So interprovincial pipelines, for example, interprovincial energy corridors, the binational waters like the Great Lakes, treaties, navigation, and this is a case as well where the impact of the activity is not constrained and can't be constrained within the provincial boundaries where it's undertaken. The Pan-Canadian framework that was negotiated by the federal government with the provinces prior to the adoption of this legislation was developed specifically in order to provide the maximum amount of room for provincial action. And there's nothing in the criminal law argument that we're arguing as the foundation for the constitutional validity of this law that would stand in the way at all of further provincial action in this case. The cap and trade laws can all continue, other carbon pricing laws can all continue, further regulation can all continue, incentives can all continue, and the only way that that would be constrained would be when complying with one law would put you offside with the other one. But just because one is more stringent or requires additional action is perfectly permissible in that kind of a scheme.
Thank you for the question. I also want to pause to thank Dwight Newman for such very generous and kind remarks. Thank you very much. So in looking at, I would agree that that would be the normal conclusion, that the provincial governments, and as you've tracked the arc of our Constitution and how it grew over the provincial responsibilities over natural resources right up to the addition of Section 92A. We recognize that. In general, provinces have authority over natural resources. We're in a new terrain where if they choose to, as you say, dig coal out of the ground and burn it, you're running up against international commitments that we've made as a country that are grounded in not political abstractions, but in exigencies that are as real as a decision by provinces to send armaments to Germany in the Second World War and to hell with survival. They wouldn't do that. I don't think they'll do that today. But the reality of the way the law is crafted, which is the key question here, is the constitutionality. Is it within appropriate use of peace, order, and good government? Even though, I agree with you, the default position would be this is provincial. That's why we stand outside of normal 91, 92 concerns and say, yes, but under peace, order, and good government, this is an area that requires very narrow, very focused federal action that leaves scope. This is certainly not exclusive. Unlike the securities law case, if the Supreme Court had approved the national securities law case, there's no room for separate securities operations at the provincial level. This leaves the province's scope in wide areas of regulation and jurisdiction, and for that matter, natural resources can continue to be, for instance, used in Alberta. The petrochemical industry, the making of plastics, making of nylon, all of those things don't involve burning carbon. It's burning carbon that's the problem, and that's why the greenhouse gas pricing mechanisms have to apply to all places where carbon is emitted.
Thank you very much.
Leonid Sirot, I'm teaching public law in New Zealand, but I also write on Canadian law. Question for the side that supports the constitutionality of the carbon tax. So if we imagine a different tack, a different approach to combating global warming, and we imagine a National Nuclear Energy Standards Act that says that every province is required to produce at least 50% of its energy from nuclear power or something like that, or all the energy that's not renewable has to be nuclear energy because that's the reliable form of zero carbon energy generation. And we're going to criminalize the purchase of other non-renewable energy, and we're going to set aside all the provincial environmental legislation insofar as it interferes with the construction of nuclear power plants, because those environmental assessments are very time-consuming. We are in an emergency, so we are setting those aside. Would that be constitutional?
I don't believe so. For one thing, it wouldn't stand the test of evidence. You wouldn't be able to make the case that that was a rational economic decision. But beyond that, what you'd be doing is impeding in provincial jurisdiction in multiple ways with a very blunt instrument. So, for instance, in your hypothetical, you'd be getting rid of provincial rights to review the environmental impacts of projects. You'd be mandating that they spend money on things they might not want to spend money on, and you'd be bypassing and forcing them to bypass cheaper and more easily. Well, you can't build a nuclear power plant in less than 15 years. I mentioned the urgency of the situation. You can roll out hydro, and small-scale run-of-the-river hydro, wind power, solar, district energy and so on so much faster. I mean, I know what you're creating is a constitutional argument. It fails on the economics, it fails on common sense, but it also would be an unjustified intrusion into multiple aspects of provincial jurisdiction. It wouldn't meet the test that came out in Crown-Zellerbach of singleness, distinctiveness, and indivisibility.
Thanks.
The one thing I would add to that is that the greenhouse gas pricing law is specifically designed in a way that allows for innovation and the pursuit of economic activity that will help reduce carbon, whereas the scenario you outlined was quite prescriptive, and then I would echo the points about the lack of evidence to support that.
All right, one last question.
Hi, my name's Hatem Kier. I'm an articling student here in Toronto working in criminal law. And my question's for Ms. McClenaghan. So if the greenhouse gas pricing falls under the criminal law power, would greenhouse gas emitters also be entitled to various criminal law rights, like the right to a presumption of innocence and the right to a fair trial and so on?
There's a difference between the criminal code offenses where those kinds of defenses are made available versus utilizing the criminal law power under the list in the federal Constitution that allows for action in order to control an evil. And so in this case, the greenhouse gas pricing law is pursuing a regulatory scheme that is controlling an evil justifiable under the criminal law power, like the Canadian Environmental Protection Act also is, with prohibitions and penalties. Now, your question, for those prohibitions and those risks of penalties, then yes, of course, they can mount whatever defenses are applicable under the rest of the jurisprudence. But in terms of the underlying validity of the law, the criminal law power is based on this regulatory scheme to address the evil.
Okay, thank you.
All right, well that ends the debate. I want to start by just thanking all the panelists for agreeing to do this debate and for coming out, taking time out of their busy schedule, especially Ms. May. I'm sure the parliamentary schedule is a little bit rough, so thank you for agreeing to do this. And join me one last time in giving them a round of applause.